Stephanie, thank you. And we are very lucky because we have Larry Alexander as our moderator. This question is what Larry would call a theory of hammers question. By theory of hammers, Larry means understanding not sort of normative ideas about what the Constitution should be, but understanding the conceptual infrastructure of how it operates. Like, for example, the difference between rule-level invalidity or facial invalidity and as-applied invalidity. That is a theory of hammers question. The first point I want to make, and I don't think it goes to much of the substance of Stephanie's paper, but it is something she talks about, and I do want to say this. This is not a question of remedy. The question whether the First Amendment makes laws invalid only at rule level or operates at as-applied level is a question about the content of the First Amendment. Similar questions about the question of the content of the applicable constitutional provision. The courts do not actually make lower level laws invalid. Invalidity is something they find. It is not something they make. If you want to put it in theory of hammers terms, if there is a tool that can actually change the content of the lower level law, the courts don't have that tool. They have something else. They have the ability to decide cases in accordance with law. In order to decide cases in accordance with law, they have to know what the law really is. They sometimes have to find invalidity. The second point I want to discuss is whether the old equity of the statute exemption cases are ancestors of as-applied invalidity under the Constitution. I'm going to say that at this point, from what we have from Stephanie, that question is open. We need to know more. That is not proven. First point is as-applied invalidity. It goes all the way back. That's found in Marbury. That's found in Hodgson against Bowerbank. It's found in Gibbons against Ogden. Not surprising, sometimes the Constitution does operate strictly at rule level. One of the earliest judicial review cases is about that kind of provision. It's possible to tell whether a tax was apportioned only by looking at the rule. You can't identify that at the level of application. The court did that in the 1790s. But they also had cases where they found that some statutes were invalid only in part. That happened for, as I say, Hodgson against Bowerbank, Marbury against Madison, and Gibbons against Ogden. It's important not to be confused by appearances of the word void. Void can mean inoperative, inapplicable in a particular situation, and indeed the court in Gibbons against Ogden, which didn't hold that the entire New York steamboat monopoly was preempted. It was preempted only insofar as it applied to a vessel with a federal coasting license. The court in Gibbons said, insofar as it does that, the New York law is void. So, as I say, don't be confused by the word void, and don't think that because the terminology of as-applied unconstitutionality developed in the late 19th century, the concept developed. No, the concept was always there. Second thing about the equitable exemption cases as possible ancestors for as-applied unconstitutionality. To some extent, I think they are ancestors for what we now call judicial review, for unconstitutionality. That may well be true. But without more, I don't think they can count as ancestors specifically for as-applied invalidity, because with that kind of reasoning, there is built in a selection bias. That kind of reasoning, the legislature, Congress, or state legislature wouldn't have wanted its broad rule to apply in a situation like that. That can apply only when there are going to be pieces of the broad rule left. A court would not say, the legislature didn't want this rule to apply at all. So that structure can arise only in a situation in which the answer, if there is one, is going to be an as-applied limitation. Hence, as I say, it doesn't show us that it's an ancestor of as-applied limitation, because whatever it is, it's going to be as-applied. That's not to say that there might not be some connection there between the later development, or perhaps the more conscious understanding, because as I say, it's not a later development, more conscious understanding of as-applied unconstitutionality. But if so, it will take evidence that I think we haven't seen yet. The third thing I want to talk about is the significance of those equity of the statute judicially discovered or judicially made exemptions for the question that we associate with Smith. That is the question, does the First Amendment operate strictly at rule level, as I would say, or does it actually also create exemptions to rules? To say that strictly at rule level means basically that It forbids rules that are aimed at religion while allowing, at rule level, general and neutral rules. And it allows the general and neutral rules even when, in certain of their applications, they interfere with religious exercise. That's the question. Is the First Amendment in general, I would say, or is the Free Exercise Clause, as one might put it, a rule about rules? Or is it about outcomes? What do those old cases tell us about that? One of the questions that Stephanie raises is the possibility that because they show a willingness of judges at the time of the framing to find judicially created exemptions, they demonstrate that Justice Scalia was wrong in his horror of judicially created exemptions. Well, the first point is he may have been. Justice Scalia had a horror of judicial subjectivity and balancing. He really, really hated that, especially when it was found in Warren Court cases. Well, yeah, Justice Scalia should not have projected his hatred of judicial subjectivity onto the Constitution. He should have been finding, not making, a rule like that. That is true. I think the question, though, whether those old equity of the statute exemption cases show an acceptance of judicial policy making, whatever you want to call it, around the time of the framing, I think that's a hard question because you have to know whether the judges really meant what they said. If they really meant, we don't think the legislature wanted to do this, we are helping the legislature, then this is not a demonstration that it was okay for the courts to engage in subjectivity or that anything like that was accepted. It was just statutory construction. Now, if these cases really were judicial power grabs, oh, the legislature wouldn't have wanted to do this. Actually, we know the legislature wanted to do this because they were a bunch of bigots and we are not. Then the cases may stand for something else. But again, on their own terms, they just stand for courts saying legislatures often have to operate at a high level of generality. We can see their applications, which they could not predict, and so we can carry out their purposes better than they can. If that's what they're doing, it's just statutory construction. It doesn't tell us anything about sort of tolerance for judicial power, judicial policy making at the time of the framing. Now a little bit more on the broader question, is the First Amendment, is the Free Exercise Clause in particular a rule about rules, and how do those old cases bear on that? Because what I just said was just about Justice Scalia and his war on judicial subjectivity. The first argument in favor of the rule level reading is just, well, the First Amendment, and here I stress the First Amendment, I'm going to come back to that. The First Amendment says Congress shall make no law. What is a law? A law is a generalization. The application of a rule is a particular, but a law is a generalization. Stephanie talks about Nick Rosenkranz's argument along those lines. I will say I used to believe something like that, but then I saw the light. The light I saw was the difference between a duty and a disability. Nick's argument is that the First Amendment imposes a duty on Congress. Congress must know whether it is complying with the duty at the time it enacts the law. Ought implies can. Therefore, the duty must apply at rule level because Congress is acting at rule level. Perfectly reasonable if you think the First Amendment implies a duty. I don't think it does. Rather, it's a disability. That's why I say I've subsequently seen the light. That's not to say that the First Amendment isn't a rule about rules. In fact, I think it is. I think that the textual argument is quite strong there, but that's not all there is to it. And I think I'm going to say two things now about the equitable construction cases. The first is they actually might be understood to make the rule about rules reading more plausible because they demonstrate that there is a safety valve in statutory construction. When the legislature accidentally legislates too broadly, the possibility, and this again assumes that the courts would be doing it in good faith and it wouldn't be just a power grab, the possibility of the court say, oh, the legislature went a little farther than they really wanted to, but on the basis of some principle or other, we can find that they didn't really want to do that. That makes saying the Constitution itself operates only at rule level a little bit less intrusive because there is, as I say, this possibility, well, to some extent, if the legislature really wanted to do it, there could be exceptions, but if the legislature didn't want to do it, if they decided they needed to operate with a genuinely uniform rule here, everybody has to serve in the army, sorry, Quakers, we just have to do it, then yes, the courts would respect that, but as I say, sometimes that may happen and the Constitution may well permit that if it operates at rule level. The other thing I want to say about the equitable exemption cases is specifically about the First Amendment. And a moment ago I said I'm talking right now about the First Amendment. I'm not sure how what I'm about to say applies to the operation of First Amendment principles to the states through the 14th Amendment. Because one of the things Stephanie says that's especially interesting, and this is on page 50, is that the courts in doing equitable construction thought they were integrating statutes into the general corpus juris of the law of the state. They were making it all cohere. Okay, that's fine. But remember, the large-scale structure, I'm drawing a pyramid here, the large-scale structure of the American constitutional system does indeed have as its base the body of law of each state, which is in principle a complete system and should be harmonious. 49 of them are the common law plus statutes. One of them is the civil code plus statutes, but both of them are complete. And there is a good reason to think that when courts understand how statutes fit into those complete bodies of law, they should indeed try to harmonize them with the principles found elsewhere in the law. That's not how the federal system works, however, when it comes to acts of Congress. Acts of Congress are interstitial. They do not form a coherent body of law that should be found to be coherent with the rest of the law of the state. Rather, the whole idea of federal law is that it is interstitial, meaning, first, it deals with particular issues. It's not a large coherent body of law, and it's not part of a large coherent body of law. Rather, federal law disrupts state law. Under Article 6, federal law displaces the state law. So the relationship is not one of coherence, such as, again, might well be appropriate if you're trying to understand a state statute in light of state values about religious freedom. Rather, it is the paradigm is one of federal intrusion into state law, and the relevant principles there are principles about how preemption operates. Does Congress mean to displace the traditional police powers of the state, for example? And maybe into considerations like that, there would feed an unwillingness on Congress's part to disrupt states, not only their police power, but what they've done to respect various rights like religious liberty. But it will come in through the characteristically federal way of reasoning that reflects the fact that Congress operates interstitially and displaces the state law. What I just said in conclusion, of course, is not only the subject matter, but the title of the greatest law review article ever written, The Relations Between State and Federal Law, so no better point on which to close.
Thank you, John. These are really helpful comments, and you've given me a lot of great food for thought. One thing that I do want to flag is that as to the question of was equitable interpretation such that we were sort of modifying or bending statutes to avoid conflicts with higher law principles, including constitutional principles, was that an early predecessor, if you will, of modern as-applied challenges? And I guess what I would say about that is the thrust of my paper isn't necessarily to prove that point. That's a point that Whittington makes in his book about repugnant laws. He says that he points to some of these early equitable exemption cases, and he says that basically quote, we seriously misunderstand how courts have exercised the power of judicial review if we overlook these early examples of laws being found unconstitutional as applied. And he has a lot of great examples and analysis in his book that I don't really improve upon, but I think that he's right, and so that's part of my story here, but that's not necessarily necessary to the argument that I'm making, which is just regardless of what this equitable interpretation ultimately evolved into, it was a case where courts were reading sometimes plainly applicable, generally applicable laws to not apply to certain circumstances that just fell within the plain language of those statutes. And so if we're just looking at it on those terms, that's essentially the same sort of thing that the New York court was doing in 1813 in People v. Phillips, was just saying, with a common law rule, we just find that this circumstance, even though it normally would fall within the general requirement here, doesn't. And that's what religious exemptions are now. And so I think regardless of how we label it, when you look at religious exemptions through that broader lens historically, they would not have been a constitutional anomaly to read statutes more narrowly than the plain language would suggest in order to avoid that conflict. As far as the question of maybe this is just statutory construction, and it's not really an exemption. From my point of view, I'm sort of ambivalent as far as what buzzwords or language or labels modern courts would use when it comes to providing religious exemptions. If we think about the Yoder case, for example, where there was a general requirement that everyone send their kids to public school for high school. And there the court, in its decision, does speak in terms of exemptions and just says, the free exercise clause requires an exemption from this statute. The court could have also, if it was speaking in more of the historical, equitable language, just said, we can't imagine that the legislature really would have meant to burden the religious exercise and destroy an entire religious Amish community, and therefore we're not going to read the statute this way. And I think I'm ambivalent as far as which way the courts speak, but what I think is interesting is that there's historical precedent for that sort of outcome, which is to say that the plain language of statutes should be read more narrowly when there's those sorts of conflicts. And then as far as, and I think that's related to the rule-based question. Does the First Amendment just operate at the level of rules? And you might be right, John. I mean, I think it's an interesting question. The First Amendment certainly does speak about Congress shall make no law. But what was interesting for me as I was studying these cases that Whittington says are early examples of as-applied challenges is the focus was always on the legislature. It wasn't on the executive who was applying the law. It was about, would the legislature have intended or anticipated that the authority they provided when they created this rule-based structure was going to be applied in this way. And so they were still operating at a level of essentially analyzing and relying on that legislative authority. And so I don't think that with that sort of reasoning and context in mind, it's inconsistent to think of those sorts of carve-outs as still being focused on Congress with a First Amendment that is also focused on Congress as the primary actor.